This is an appeal of the matter of XR Touring LLP v. Javor Anr.
Yes, Mr. Golding.
May it please the court, I appear together with my learned friend Miss Rooney on behalf of the appellant XR Touring LLP, to whom I shall refer as X-Ray. My learned friend Mr. Reid, King's Counsel, appears for the first respondent, Mr. Javor. My learned friend Mr. Adam Solomon, King's Counsel, appears for the second respondent, to whom I shall refer as WME or William Morris. Lords, the central issue on this appeal is whether the judge was right to decide on a summary basis that a term in the contract of employment between X-Ray and Mr. Javor, that Mr. Javor should pay X-Ray any commission received on concert bookings discussed, scheduled, made or contemplated when he worked at X-Ray, whether or not such bookings took place before or after the termination of his employment, is unenforceable as an unreasonable restraint of trade. We submit that the judge was wrong to strike out the claim or grant summary judgment on that basis against X-Ray because, in short, first, the issue whether a contractual term is an unreasonable restraint of trade is highly fact sensitive, and for that reason the enforceability of the commission provision should be fully investigated at trial, along with the enforceability of the non-solicit provision, which the judge decided should go to trial. Both of those provisions require detailed consideration of X-Ray's business, in particular its relationships and those of Mr. Javor with artists whom they represent. And the fact-specific nature of the case, we say, is relevant to a number of issues, including first, the construction of the commission provision, and secondly, whether it's a restraint of trade, and thirdly, if so, whether it's reasonable. Second, we say that the necessity of a full factual investigation is a fortiori here, where the commission provision is not a direct restraint of trade of the kind typically found in employment contracts, such as a non-competition or a non-solicitation or non-dealing covenant, but it's a provision which the judge held to be an indirect restraint of trade, but which we submit is unlike any other indirect restraint of trade which has been considered in the reported cases. And third, we submit that there is a real prospect that following full investigation at trial, it would be decided that the commission provision is not a restraint of trade, or if it is, then it is reasonable, subject to such severance of unreasonable parts as may be considered necessary. Lords, before I go further, could I indicate to the court that, subject to the court, the parties have agreed a split of time today broadly along these lines. I will aim to sit down by 12:30. My learned friends between them would then have until about 3:45, and I would then have time to reply. I might go over 12:30, but if I do, I'll take that off my reply time, if that's convenient to the court.
That sounds admirable, and advance notice to Mr. Reid and Mr. Solomon. They will no doubt carve things up so that we don't go over the same ground twice.
Thank you, Lord.
Yes.
Subject to the court, I propose to make some opening remarks before turning to the individual grounds of appeal. And can I deal under the heading of opening remarks with three matters? First, the factual background. Second, clause 13. the commission provision, and third, the judgment below. Turning first then to the factual background, of course, in considering this, one is principally concerned to identify the relevant background for the purpose of deciding the meaning as well as the enforceability of the commission provision. It's well established that the proper construction of a clause in a contract and its enforceability, if it's in restraint of trade, is to be assessed as at the date of the contract when the provision was entered into. That, however, is subject to the important qualification that subsequent events are relevant insofar as they may shed light on what might have been fairly contemplated as the clause's meaning. And for that, could I just refer the court to Coppage and Safety Net, which is in the authorities bundle at tab 17. The facts of the case are not relevant for this particular point, although in passing I note it was a 6-month covenant that was a non-solicit covenant that was held to be enforceable. But at paragraph 9, page 343 of the bundle, Sir Bernard Ricks sets out a helpful summary of general principles relevant to the validity of a restrictive covenant in an employment contract. Could I just invite the court to read to itself paragraph 9, and I'll highlight certain elements of it.
Yes.
We invite the court to highlight subparagraph 5, particularly the words in brackets at 6
Yes.
And 8 are also of relevance for today's purposes. The principles applicable to construction of contracts in general have been explained in numerous authorities and will be well known to this court. We refer briefly to 2 authorities relevant on construction. Firstly, Rainy Sky, with which the court will be familiar. That's in the authorities bundle at tab 15. In particular, we rely on paragraph 21 in the judgment of Lord Clark, which is at page 294 of the bundle. The language used by the parties will often have more than one potential meaning. And he refers then to construction being essentially one unitary exercise in which the court must consider the language used and ascertain what a reasonable person, that's a person who has all the background knowledge which would reasonably have been available to the parties in the situation in which they were at the time of the contract, would have understood the parties to have meant. The court must have regard to all relevant surrounding circumstances. If there are 2 possible constructions, the court is entitled to prefer the construction which is consistent with business common sense and to reject the other. And then finally at this, on this point is the case of Boydell, which is in tab 23 of the bundle, page 489, with which my Lord Justice Bean will be familiar. And in particular, we ask the court to read paragraphs 23 through to 26 on page 493.
Yes.
Thank you. So paragraph 26 is what's often referred to and is here as the validity principle, where there are two alternative realistic constructions of a contract. Lords, against that background, can I turn to the factual matrix as at the date of the contract? The contract was made on the 29th of June 2022, effective as of the 1st of April 22. If one can briefly turn it up, it's in the core bundle at tab 9, page 126. And one sees that in type form that there is a date near the top of May 22. The heading shows that the contract is to run from 1st of April 22 to 3rd of March 23. Clause 1 identifies its effective date as the 1st of April 22. One turns over to page 128, one can see it signed by Mr. Javor on the 29th of June 2022. So the court, in considering the proper meaning of the commission provision and whether it's an unreasonable restraint of trade, must, in the language of Lord Clark, have regard to the background knowledge which would reasonably have been available to the parties in the situation in which they were in June 2022. That background knowledge includes a number of important elements that are discussed by Mr. Huffam in his witness statement. It might be helpful just to have that open. I'm going to seek to summarise certain elements. His statement is in the first supplementary bundle at tab 5, and he picks up the discussion at page 29, paragraph 4. We emphasise 5 features of the relevant background knowledge discussed by Mr. Huffam. The first is the business of X-Ray. It was founded in 2005. It's, as the court will have seen, a booking agency, represents artists largely in the popular music industry in relation to live concerts, which range from small local venues to music festivals and concert tours. The number of people working at X-Ray isn't large. Mr. Huffam says in paragraph 10, as at the date of his statement, the head count stood at 18. and it's reasonable to believe it was a similar figure in June 22. So that's the business in short. Secondly, the relationship between agents and artists is an important feature. Individual agents worked for particular artists. They were responsible for particular artists. In paragraph 4, Mr. Huffam explains, X-Ray was founded by him and a number of other senior and experienced booking agents who were then working for different booking agencies. And in paragraph 10, he says that he was personally the agent for certain established stars, which he names. Steve Strange was another founder of X-Ray. Mr. Huffam describes in paragraph 11 how Mr. Strange was a very successful booking agent before and during his time at X-Ray. The artists represented by Mr. Strange include well-known artists such as Coldplay and Eminem. And according to Mr. Huffam in paragraph 14, when Mr. Strange died in September 21, he represented around 180 artists. As he says, in almost all instances, that was worldwide exclusive representation. I emphasize exclusive. So such artists were not represented by other booking agencies, but only by X-Ray. The way in which particular agents represented the artists is an important part of the background. It's apparent from the statement that X-Ray had lead agents, such as Mr. Huffam and Mr. Strange, who together with their support teams of other booking agents represented particular artists. Mr. Huffam explains in paragraph 13 that whilst often an agent has a direct relationship with an artist or a manager, the agent needs help and support, and at X-Ray over time, Mr. Huffam, Mr. Strange and other lead artists built up support teams. So the relationship between agents and artists is the second important feature. Thirdly, the booking agent's role is described by Mr. Huffam, particularly in paragraph 8. The booking agents work with promoters who stage concerts and pay the artists. They also work, of course, with the artists whom they represent and their managers and representatives in a myriad of ways. One important responsibility of the agent relates to payments to the artists. At 823, Mr. Huffam explains the agent negotiates terms with promoters, ensures that the money to be paid to the artist is adequately secured in advance of a concert taking place. And at 824, he says that artists can be paid a fixed fee as well as a percentage of box office takings. And X-Ray works to ensure the artist's income is fully collected in a timely fashion. So it's clear from that evidence that the payment of fees to an artist for a concert, and hence the payment of commission on those fees to the booking agent, might only occur late in the process that starts with the idea of a concert and ends with its performance. And along the way, the artist might do a lot of work, the agent might do a lot of work on behalf of the artist before the concert takes place and before any payment is received from the booking agency for that work. As Mr. Huffam explains in para 9, a key to the success for the agency is the closeness of the relationship between agent and artists. That concerts are booked sometime in advance is not surprising. It's borne out by some of the documentation which Mr. Javor produced during his employment at X-Ray. If I could ask the court to turn up in the same supplementary bundle, tab 59, page 216. One can see here an example of a schedule of bookings At the top left-hand corner, it refers to, in abbreviation, Queens of the Stone Age, November 23 schedule. One of the artists represented by Mr. Strange and Mr. Javor. The schedule itself is dated the 3rd of August 23, and one can see over 2 pages it refers to concerts taking place in November of that year, some 3 months ahead, with much detail about the concert venue, timings, promoter, and so on. The court has already seen reference to Coldplay as one of the artists represented by Mr. Strange and Mr. Javor. If one could turn to tab 24 in this bundle, at page 136, I hope the court has a slightly enlarged version of this that was lodged, I think, within the last few days, because the original was really quite small and difficult to read. If not, we have copies that I can hand up. Sorry, it hasn't found its way to the court. But what one sees, whilst that's being located and handed up, is this is a headed Coldplay 2025 schedule, and the date is the 4th of May 2023, and it identifies a schedule of Coldplay concerts in 2025, and one can see they include scheduled concerts at Wembley Stadium in 2025. There is an email exchange about the Coldplay concerts. Could I ask the court just to turn up tab 45, please? Page 193 behind tab 45. Is an email from a Matt Woolliscroft of SJM Concerts, that's a concert promoter, dated 3rd of March to Mr. Javor, and it concerns Coldplay dates in 2025, certain dates being held, and a discussion about whether they might clash with football fixtures at Wembley Stadium. If one turns back to page 192, one can see an ongoing discussion between Mr. Javor, the concert promoter, and then with Coldplay itself, when it's apparent that by June 23, Coldplay has first pencil, as it's called, on particular dates at Wembley Stadium. And then finally, in terms of the documents produced by Mr. Javor during his employment relating to these bookings, if I could ask the court to turn to tab 54. This is a letter from X-Ray solicitors to Mr. Javor solicitors of the 12th of July 23. So that is whilst Mr. Javor is still an employee of X-Ray, but he has resigned, his employment terminated on the 17th of August. And if one turns over to page 207, paragraph 7 at the bottom, Russell's ask Mr. Javor to list all the concerts by artists with whom he is presently working that are made, scheduled, being discussed or in contemplation, providing full particulars in each instance. That's paragraph 7 at the bottom of page 207, using the language there of the commission provision. The answer is found behind the next tab, tab 55, at page 210, where Mr. Javor's solicitors reply attaches a list of all booked concerts by artists with whom our client is currently working. you've already seen a version of this on a WP basis. Say we have updated the schedule to include a Coldplay tour to be announced the following day, and updated the commission figures to reflect changes that have occurred in relation to these tours. The schedule itself, in a redacted form, redacted pursuant to the direction of my Lord Justice Bean when granting permission, is found in the core bundle at tab 13. And one can see its headed schedule of bookings, and it has a number of columns. On the left-hand side, artist. There are 37 artists there listed. A description, date of the bookings. And just on that, one can see the bulk of them are in 23. In fact, 37 of the 42 bookings are in 2023. 2 are in 23/24 and 3 are in 24. And then there's a column headed estimated commission for each individual booking, with a total estimated commission figure of just over £3 million. And there's a footnote attached to the estimated commission column. So one can see the way in which bookings are worked on, are scheduled some way ahead of them taking place. The fourth feature of the background that we emphasise is Mr. Javor's role. Mr. Huffam explains in para 14 of his statement that Mr. Javor joined X-Ray in 2008, having worked for a record company. Mr. Strange recruited him to be part of his support team and to help Mr. Strange build relationships with artists and those working with and for the artists. Throughout Mr. Javor's time at X-Ray, that is from 2008 until Mr. Strange passed away in September 21, Mr. Javor reported to Mr. Strange and became what Mr. Huffam describes in para 15 as Mr. Strange's trusted right-hand man. And then finally, by way of background, we emphasise the circumstances following Mr. Strange's death in September 21. Paragraph 16 of Mr. Huffam's witness statement, that's page 32 behind tab 5. He describes the circumstances around and following Mr. Strange's death. Before his death, he says Mr. Strange told his co-founders, that's Mr. Huffam and Mr. Thomas, that it was his wish that Mr. Javor should inherit his, that's Mr. Strange's, stable of artists at X-Ray. And of course, by then, Mr. Javor himself built relationships with those artists over the 13 or so years that he'd worked for X-Ray. Mr. Huffam then explains in para 17 that negotiations started in around February 22 between X-Ray and Mr. Javor as to the terms on which Mr. Javor might graduate from being an employee of X-Ray to becoming a member of the LLP. And one of the items discussed was how Mr. Javor would honour and respect Mr. Strange's legacy and share income from his artists with his daughter, who survived him. At that time, in February 22, Mr. Javor didn't have a written contract of employment. And since the negotiations regarding Mr. Javor's potential membership of the LLP were somewhat protracted, and he had at that time, as Mr. Huffam puts it in paragraph 20, become a point person for Mr. Strange's artists, X-Ray considered it prudent to enter into a written contract with Mr. Javor, and Mr. Javor agreed. That Mr. Javor at this point saw himself as having built a roster of artists at X-Ray together with Mr. Strange is apparent from a press statement that William Morris issued shortly before the termination of Mr. Javor's employment with X-Ray. One sees that press statement behind tab 65 in the supplementary bundle at page 228. The evidence is that William Morris issued this on the 14th of August. It bears a date of the 16th, as one sees at page 228. And in the second paragraph, it says that Javor comes from X-Ray Touring, where for the last 17 years he has guided the careers of a diverse range of artists. And then there are 32 artists listed in that paragraph. Miss Dickens of William Morris in the next paragraph refers to that as a roster of artists built by Mr. Javor. And in the next paragraph, Mr. Javor himself is quoted as saying, "Steve Strange and I built an incredible business at X-Ray over the last 18 years through teamwork and passion for our artists. I'm excited to start this next chapter at WME and to continue this legacy with the team in London." That then, in summary, is we say the key features of the background knowledge that would reasonably have been available to the parties when entering into the contract in June 2022. Can I turn then to the contract?
Let me ask you one aspect of Mr. Huff on the statement. Paragraph 17. Firstly, it refers to 17.1, the period of time from which Josh would graduate from employee to an X-Ray member. Does that mean limited partner?
It would mean member of the LLP. Yes.
Secondly, 17.3, how Josh would honour and respect Steve's legacy, in particular by sharing income received from Steve's artists with Steve's family. How would Josh do that as an employee?
What he's discussing in paragraph 17 is the terms on which Mr. Javor would become a member of the LLP if he progressed to being a member as opposed to an employee. And those terms clearly anticipated some arrangement whereby part of the commission generated by Mr. Strange's clients, as they originally were inherited by Mr. Javor, would find its way to Mr. Strange's
Through his membership share?
Something of that nature. There's no further detail in the evidence, but that's what I understand.
There's nothing in the evidence about how the commission is actually invoiced by X-Ray. Presumably they invoice their client for commission.
There's nothing in the evidence as far as that is concerned.
Does the booking agent, as you refer to him, the employee, personally receive commission?
That's not my understanding. My understanding is that the commission is received by the agency.
Into its bank account?
Yes. So, for example, in relation to particular concerts, I understand that there's an advance payment made at some stage, which is a payment from the promoter ultimately to the artist. The agency will deduct some of its commission from that payment as it passes through its account.
Remuneration goes through the agency's bank account?
At least part of it is my understanding, it does. Yes, I can't stand here and say the totality of it. My understanding is part of it does. And then, of course, once the concert has taken place, particularly where the artist payment is dependent on the revenues generated by the concert, then the final payment will be made of the fees to the artist and the commission to the agency.
Well, the commission will be paid by the artist.
Yes, quite right, but the route that it takes is, as I understand, at least in part, payment coming from the promoter through the agency to the artist, and the agent deducts its commission. Well, I hope that answers my lord's question so far as I can. Turning then to the contract, turning back to the contract, it's core bundle tab 9, page 126. We looked at it a moment ago. And we saw in clause 1 on page 126, it's a fixed term contract until the 30th of March 23, that's the term. In fact, it was continued by agreement after the 30th of March 23, as I've indicated, until the 17th of August 23. The salary is at clause 4 on page 126. And the post-termination obligations, clause 13, is at 127. If it assists the court, that clause 13 is set out in rather larger type behind tab 10 of the bundle, page 147. And one can see that it comprises 4 sentences. The first sentence is the non-solicit provision. So Mr. Javor won't, for 12 months after termination, solicit, amongst others, artists who were in the previous 12 months an artist of the company with whom he had contact. That's the first sentence. The second sentence concerns interference with supplies that we can disregard for present purposes. The third sentence concerns the payment of commission, is the key sentence for the purpose of the appeal. All commission and other monies related to bookings or potential bookings discussed, scheduled, made or contemplated, whether or not actually contracted or to be made prior to the date of termination of your employment, whether or not such bookings are to take place after the end of your employment, shall belong to the company, and if any such commission or other monies are received by you or any other person or entity associated with you, including any future employer, you undertake to hold such monies on trust for us and pay to us immediately all such monies without deduction or set-off. And then the fourth sentence, you shall ensure all such bookings are contracted by the company. The company should be entitled to receive 100% of the applicable commission payable. The principal dispute between the parties concerns the third sentence, but the third and fourth sentences are certainly in play. And at the outset, it's necessary in our submission to ascertain the meaning of the commission provision, and in particular the third sentence. In our submission, the third sentence means that Mr. Javor will pay to X-Ray commission on concert bookings or potential bookings discussed, scheduled, made or contemplated by you, i.e. by him, prior to the date of termination of his employment. Now, the first defendant argues that the provision purports to capture all bookings made or contemplated by employees, by any employees or members of X-ray. It's paragraph 6A of Mr. Reed's skeleton. And he goes on to say that's the case even if Mr. Javor had no knowledge or any involvement in the same. We say that's not the correct construction. It involves reading in the words by employees or members of X-ray after the word contemplated. And it's true that the Commission provision doesn't expressly state by whom the bookings are to have been discussed or scheduled or made or contemplated. It doesn't say expressly by any employee or member, which is Mr. Javor's construction. It doesn't expressly say by you, which is our construction. So it is a case where the court has to decide what the parties objectively intended.
Well, if you read it absolutely strictly, it doesn't even say it's anything to do with the company.
Right, well, and clearly that's not right. So one has to work out who it is that has to do the discussing, scheduling, making or contemplating. And the court will have to, of course, have regard to all the relevant surrounding circumstances. And we submit that our construction, that this really means discussed, scheduled, made or contemplated by you, by Mr. Javor, is to be preferred for two principal reasons. First, we say quite simply, against all of the background knowledge that we've identified, that is what the parties objectively intended. It is what a reasonable person who has all of that background knowledge would have understood the parties to have meant by the words that they used.
Forgive me, but the starting point before we look at that would be you look at the language of the clause, and you have to read the whole clause together, don't you? You don't, though it's been divided up, and you're focusing now on the third part. You read the whole clause, and what the clause is, what the earlier provisions are relating to is Mr. Javor.
Yes, well, I respectfully agree, and I'm perhaps abbreviating the submissions in the interest of time, but of course, in any construction exercise, one looks first at the particular provision, which we'd say is the third sentence, then one looks at it in the context of the whole of clause 13, and then one looks at it in the context of the contract as a whole, and then against all of the relevant background knowledge, and one knows that construction is an iterative exercise. It's textual and it's contextual. And we say one carries out that exercise, and certainly looking at this clause as a whole, it is concerned with what Mr. Javor does, it's concerned with his relationships with artists, and therefore the third sentence is referring to discussion, scheduling, making or contemplating by him. We say that is the objective intention, particularly when one considers that clause 13 is entered into in 2022 to protect X-Ray's interests in light of the fact that Mr. Javor has just inherited Mr. Strange's roster of clients and was representing them by booking concerts for them. It's work that he does, we say that this provision was clearly intended to cover. The second reason is insofar as it's suggested that by Mr. Reed that there's an alternative construction, and this could refer to any employee or member of LLP doing these things. We say that's not a realistic construction, but if we're wrong on that, and it is, then our construction is consistent with business common sense, whereas Mr. Javor's is not. At least ours is more consistent with business common sense than his. And in asking, well, what construction is more consistent with business common sense, one would ask, is it Mr. Javor's construction whereby he would have to pay commission to X-Ray from all concert bookings which he or his future employer receives, where another X-ray employee had worked on those bookings without Mr. Javor's involvement or knowledge? Or is it the construction we prefer, whereby Mr. Javor has to pay that commission where it was him who worked on those bookings? And we say plainly the latter construction is consistent with business common sense, the former is not. Therefore, we say that construction is correct. It should determine or be the foundation of considering the strikeout and summary judgment application. Alternatively, the court on this application should decide that there is a real prospect that the construction that we advance would be held to be the correct construction should the matter go to trial.
I'm not sure you find much reflection of this part of your submissions in the judgment below. Is that because it wasn't? I mean, why is that?
Well, my lord, it was the next point I was about to make. It's a notable feature of the judgment below that the judge did not engage in the construction exercise so far as the commission provision is concerned. There's no section of the judgment where he addresses what the construction of the commission provision is.
I don't think, do we have the skeletons from below?
We do.
Oh, we do, indeed. I haven't looked. Was this issue raised?
I believe it was raised, my lord, but I wasn't in the court below, so I'm afraid I don't have a recall of the argument, and I'm sure I'll be told from behind precisely where this is dealt with in the skeleton. But
I haven't looked through the skeletons below to see.
Lord, they're in the supplementary bundle, and it's tabs 7, 8 and 9 where one finds the skeletons below. But my lord, and I'll come back and answer my lord's question if I may.
Yep.
But the key point is the judge does not deal with this construction point in terms, and that is the foundation we submit to any finding as to whether or not the commission provision operates as a restraint of trade, or if it does, whether it is reasonable, and that is an error not to engage with that exercise. Lord, I was then, just by way of final opening remark, about to turn to the judgment below, just so one can see the flow of it. I know the court will have read it. It's in the core bundle at tab 8. It's in 5 parts, page 89. Paras 1 to 4 is the introduction. Then there's an outline of the facts from paras 5 through to 27. Starting at para 28 on page 92, the judge deals with the non-solicitation covenant. That's the first sentence of clause 13. And at para 29, he identifies the issues arising on the non-solicit, which of course he allowed to go to trial. Whether there's any real prospect of the covenant being found enforceable, if so, whether there's a real prospect of the claimant proving breach, and if so, inducement of breach. At paras 30 to 54, he summarises the submissions of the parties. And at 55 to 73, he sets out his reasoning and conclusions relating to the non-solicit. And I just note and invite the court to note in passing, at para 56 he decides there's an issue fit for trial as to whether the non-solicit is enforceable. And he refers there to the relationships between Mr. Javor and X-Ray's artists. At para 57, he says the covenant is arguably not too long. 58 to 59, he decides the work done by other employees of X-Ray is a matter for trial. At 61, he refers to Mr. Javor's access to X-Ray's clients. 63, he deals with communications regarding Coldplay concerts. At 67, he finds a relevant matter for investigation at trial is the roster of artists that Mr. Javor inherited from Mr. Strange. And at 68, another matter for trial is Mr. Javor's desire to continue the legacy of the business he built with Mr. Strange and his artists at X-Ray. And then at 73, we see the judge dismiss the application to strike out the non-solicit. So that is going to trial anyway. And then at 74 to 106, he dealt with the commission provision. 76 to 90, the judge summarised the parties' submissions. And then at 91 to 106, he stated his reasoning and conclusions. And I'll come back to this in more detail. But just to highlight, there's some preliminary remarks the judge makes between 91 and 98. And then at 99 to 101, he deals with the first question, whether the commission provision operates in restraint of trade. That's those 3 paragraphs. Then at 102 to 103, he deals with its reasonableness. And then at 104 to 5, the claim against WME. So that is the scope and flow of the judgment, and as I say, I'll come back to some individual passages in the course of dealing with particular grounds of appeal. Lords, can I then turn to the grounds of appeal? And it might be helpful to have our skeleton argument in this court to hand, which I will refer from time to time. That's in behind tab 1 of the call bundle. And we deal with the first ground on page 14, paragraph 36 onwards. The first ground is that the judge misdirected himself as to the relevant legal principles on strikeout or summary judgment, or misapplied those principles. The judge, of course, at paragraph 4 of the judgment paragraphs 3 and 4 referred to easy air and the approach to summary judgment applications summarised by Mr. Justice Lewison in paragraph 15 of his judgment in that case. And in those 2 paragraphs, the judge paraphrases Mr. Justice Lewison's approach. We don't take issue with that summary, abbreviated though it is. But what we do say is, in striking out the commission claim, the judge erred by failing to take into account a relevant factor, namely, that there will be a trial of the non-solicitation claim in any event. Now that factor is one to be weighed in this exercise, as made clear in a number of authorities. We referred to one, Partco against RAG. Could I ask the court to turn that up? It's Authorities Bundle tab 6.
Is there really going to be a trial of the solicitation in any event?
There is, my lord.
Have any damages been pleaded?
Well, loss and damage is pleaded. It was a point taken for the defendant before Mr. Justice Carr that there wasn't particular loss that was proved. He rejected that submission on the basis that in circumstances where the breach that's alleged is solicitation by WME and Mr. Javor of its artists in the form of the press statement and the press articles that followed, that was likely to give rise to loss and damage, because if there was solicitation by Mr. Javor of those artists, they were encouraged to move to WME, then that would cause loss. to X-ray. The judge accepted that and said that therefore there should be a trial of the non-solicitation claim. And at that trial, several issues will inevitably arise based on the arguments put before the judge below. Is the non-solicit enforceable or not? If it is enforceable, was there in fact a breach? And if there was a breach, was there an inducement by WME? Those are matters which are proceeding to trial.
Yes, but there was successful solicitation during the 12-month period, where does that get you?
Well, if there was no solicitation, then that defeats the claim. So at the moment, the judge decided that there is evidence of solicitation, that it is arguable, more than arguable, to satisfy the strikeout or summary judgment test, that there was solicitation, and he decided that is a matter that must be tried. And so that is going to trial, my lord.
If the judge was right as to restraint of trade and right as to unreasonableness, then what impact does it have on that assessment that there might be a trial in respect of another part of the clause?
Well, my lord, the matters to be investigated at the trial on the non-solicit point, as I've sought to indicate, will include the nature of the relationships between Mr. Javor and the artists, the extent to which they would be interested in following him if he went to another booking agency. All of those matters will need to be investigated at trial in deciding whether or not the non-solicit is enforceable. Those are also matters that would need to be investigated in determining the enforceability of the commission provision. So the point that we make is that when one is considering whether or not to strike out or grant summary judgment on one issue in an action, it's relevant to take account of the fact that there will be a trial anyway on another aspect of the claim, another issue. And it's not simply here a trial on an unrelated issue. It is a trial on an issue where there is overlapping evidence. And that, in our submission, is a factor that should have been taken into account by the judge, but wasn't. Can I just show, my lords, the comment in Part Co by Lord Justice Potter. It's in the Authorities Bundle, tab 6, at page 129. It's in the left-hand column, paragraph 27. It's subparagraph 3 in that passage, where Lord Justice Potter says the court should be slow to deal with single issues in cases where there will need to be a full trial on liability involving evidence and cross-examination in any event, and or where summary disposal of the single issue may well delay because of appeals the ultimate trial of the action. And our short submission is that the decision of the judge here fell foul of the two vices mentioned by Lord Justice Potter. There is to be a full trial on liability regarding the non-solicit covenant involving evidence and cross-examination that in our submission will be relevant also to the enforceability of the commission provision. And summary disposal of the single issue here, the commission provision, has in fact delayed the ultimate trial of the action. We are now 18 months on from these proceedings being commenced, and there have been no defences yet. And that factor and these two elements, which Lord Justice Potter says should be considered when deciding whether or not to grant summary judgment or strike out, were not taken into account by the judge, and we say they should have been. Can I then turn to ground 2, which is that the judge wrongly decided that there is no real prospect at trial of a finding that the commission provision does not operate in restraint of trade. We deal with this in paras 38 to 44 of our skeleton. Can I start by summarising what our argument is on ground 2? We say that there is a real prospect that following investigation at trial, a judge would find that as at the date of the contract, the commission provision was unlikely to cause Mr. Javor to refuse to represent artists on whose contract bookings he had worked at X-Ray in the event that they followed him to another booking agency, or that it was going to diminish his prospects of employment. And the reason we submit that there's a real prospect of that finding follows from a careful consideration of the circumstances obtaining at the time the contract was entered into, to which we've already referred. And just to recap, Mr. Javor had worked with Mr. Strange's clients for about 14 years and built up a relationship with them. Mr. Strange had expressed his wish that Mr. Javor should inherit those clients once he had passed away. That roster of clients was a hugely valuable source of work and income for Mr. Javor and any booking agency that might employ him long into the future. And therefore, Mr. Javor would want to maintain his relationships with those artists, and any future employer would want him to do so because of the huge benefit that they stood to gain in the long run. And it's in those circumstances that if Mr. Javor had worked on a concert booking for an artist whilst at X-Ray, and that artist wanted Mr. Javor to continue working on that concert booking if he moved to another booking agency, the commission provision would, in our submission, not deter him from doing so. Because the alternative for Mr. Javor would be to refuse the artist's request for him to complete the work on a particular concert booking, thereby risking the fracture or rupture of his relationship with that artist and sending the artist back into the arms, most probably of X-Ray, who would have an opportunity then to nurture that particular relationship. And we submit that is not something that Mr. Javor would be willing to entertain. Instead, what he would do is want to retain the artist's goodwill and loyalty, complete the work on that particular concert, even if that meant paying commission on that particular concert to X-Ray. So that is how we put the argument under ground 2.
How would he do that? Assuming he's left X-Ray, he's now employed by somebody else. How would he pay commission?
Well, the likelihood is that the booking agency would pay the commission in those circumstances. Now, the liability, of course, is a liability under the contract of Mr. Javor. He is the one who is liable to pay, but the reality is, in our submission, that the booking agency would make that payment, which is exactly what has happened. That's the subject of our supplementary skeleton argument. I'm going to come on and deal with that later and invite the court to read it. But in fact, what has happened very recently is William Morris has paid X-Ray commission on concert bookings that William Morris has received, on which Mr. Javor worked before he left his employment. And that is the practicality. We say that's the reality of the matter. That is what would happen, because any other booking agency would want Mr. Javor to hold on to those clients and not say to them, I can't deal with this concert now anymore because I dealt with it when I was at X-Ray and I will have to pay X-Ray the commission and it's not worth it. That is not, in practice, what would happen. See the press statement put out by WME as to how important this roster of clients was that Mr. Javor was purporting to bring with him, that they wanted to benefit from. And that goes to the heart of the question as to whether or not this provision would operate in practice as a restraint of trade. And it's important to bear in mind as well that there was no evidence before the judge from Mr. Javor on this or any point. He didn't put in any evidence to say that the commission provision would cause him to turn away artists who wanted him to continue working on their bookings. And that is a weighty factor to bear in mind. Now, that then is how we put the argument on ground two. Can I just take the court briefly to three authorities which are relevant on this point, to which reference was made below, and say at the outset, of course, we recognise that there are many cases in this field that deal with direct restraints of trade in employment contracts. You won't compete, you won't solicit, you won't deal, and so on. The courts have also recognised what are referred to as indirect restraints of trade. So an individual might receive a payment provided they don't compete. Case where employer says, well, pay you a pension once you've left us, provided you don't complete. And the courts have said that's an indirect restraint of trade. And the test that the courts have adopted for whether a provision is a restraint of trade is whether or not, in practical terms, it amounts to a restraint. There are three authorities. The first is quantum actuarial, which is at tab 21, page 437. This case concerned restrictions during and after the currency of a contract. Lady Justice Carr dealt with whether the doctrine of restraint of trade applied, and if so, whether the provisions were reasonable. At page 455 of the bundle, at paragraph 54, she starts off by saying the definition of a covenant in restraint of trade presents peculiar conceptual difficulty. And she goes on 6 lines down to say the courts have made no apologies for refraining from any attempt to identify the dividing line between contracts which are and are not in restraint of trade. It's been described as uncertain and porous. Then at paragraph 60 over the page, on page 457, at little Roman 5, she says the assessment of application of the doctrine is to be carried out by reference to the position as at the time the contract is made. How the contract turns out may be relevant only insofar as it furnishes evidence of the nature of the contract in question when made. And then at 6, she says the application depends less on legal niceties or theoretical possibilities than on the practical effect of the restraint in hampering the freedom to trade. And she refers there to Stenhouse. At 61, she says the approach in analogous factual situations may be of assistance in determining the correct approach, but is unlikely to be determinative because of the fact-sensitive nature of the exercise to be carried out. And then finally, over at page 460, at paragraph 68, she identifies 3 steps to be considered. 1, whether or not in practical terms the restraints in the covenant amount to a restraint of trade. 2, if so, whether or not the covenant should be excluded from the application of the doctrine. and 3, if the doctrine is engaged, whether or not the covenant is reasonable by reference to the private interests of the parties. So is it a restraint? If so, is it subject to the doctrine? And if so, is it reasonable? Now, Stenhouse is the next authority which the judge was addressed on. That's behind tab 1 of the bundle.
Just a moment.
This case concerned an insurance broker.
Just pause for a moment.
Yes, well.
Sorry, yes, Stenhouse.
Well, Stenhouse tab 1, it was an insurance broker who entered into client non-solicitation and non-dealing covenants. And one can see from the head note, picking it up at the top of page 4, there were 3 clauses that were relevant. Clause 4 provided he would not for a period of 5 years solicit insurance business. Clause 5 provided that in the event any client of the company should within a period of 5 years place insurance business, so the respondent received or became entitled to receive a financial benefit, he would pay 1/2 share of the gross commission in respect of that transaction. And clause 6 provided that the respondent should not for a period of 3 years act as insurance broker for the client. And the Judicial Committee of the Privy Council held that clause 4 was reasonable, but clauses 5 and 6 were not. Clause 5 being a restraint of trade. Can I then just highlight certain passages through the report? If one turns to page 7 of the bundle, just between letters C and D, you can see that there is reference there to the trial judge having made a finding which was supported by evidence. And I flag that because it was suggested below and the judge might well have proceeded on the basis that there was no trial in Stenhouse, that it was a summary disposal. 396 on page 8 of the bundle, again between B and C, there's reference to the reasons given by the trial judge. And at 400, page 12 of the bundle, between G and H, there's reference to the evidence in the case. Then if one goes over to page 402 of the report, page 14 of the bundle, at letter G, Lord Wilberforce says, whether a particular provision operates in restraint of trade is to be determined not by the form the stipulation wears, but as the statement of the question itself shows, by its effect in practice. Below H, the clause in question here contains no direct covenant to abstain from any kind of competition, so the question to be answered is whether in effect it's likely to cause the employee to refuse business, which otherwise he would take. Or looking at it another way, whether the existence of this provision would diminish his prospects of employment. And then he goes on to explain why their lordships had no doubt that that clause operated in restraint of trade. And just above C, he says it must be appreciated that clause 5 is closely linked with clause 6. Indeed, if one reads them together, the two clauses amount to a restriction against acting as insurance broker for clients unless payment is made according to clause 5. There are, in our submission, 3 important points to note about Stenhouse which distinguish it from the present case. The first is, as I've mentioned, the decision was made after a trial, at which the judge made findings of fact. It wasn't a decision on a summary basis. Secondly, the commission provision in Stenhouse was closely linked to the non-dealing clause, as we see from 403C. There's no non-dealing clause in the present case. And thirdly, the commission provision in Stenhouse concerned new business placed by a client after termination of the employee's employment. It had nothing to do with work started by the agent before the termination of the agency, which of course is what this commission provision is concerned with. So the relevant provision in Stenhouse was not materially similar to the present commission provision. And the third and final authority of this trilogy is Marshall against NM Financial Management. That's at tab 3 of the bundle. This case involved a self-employed sales agent engaged by a financial services company to sell life insurance and pension policies. At page 29 of the bundle, the relevant commission arrangements are set out, and one sees at letter B on this page that clause 2E provided that entitlement to commission would cease on termination of the agreement. 29 at B to C. But clause 10 at G by letter E provided that if at the date of termination the agent has for a period of not less than 5 years been continuously an agent, and either one within the period of 1 year after the date of termination does not become an independent intermediary, or two at the date of termination has attained the age of 65 years, then the company shall pay the agent renewal commission. And at 1465 of the report C to D, Mr. Jonathan Sumption, sitting as a High Court judge, found that 10G1 was a restraint of trade. In our submission, Marshall is distinguishable from the present case for two reasons. First, it expressly provided that the agent would receive a payment to which he wouldn't otherwise be entitled on commission. He didn't compete for a year. On any view, that was a financial incentive not to compete. But in the present case, in contrast, the commission provision doesn't provide for any payment to Mr. Javor of commission to which he wouldn't otherwise be entitled on condition he doesn't deal with artists. It's simply a mechanism to ensure that X-Ray receives commission on concert bookings on which he worked whilst at X-Ray. And second, in Marshall, the clause was not concerned to ensure the defendant received payment for policies sold. That was already assured because the policyholder, of course, paid the premium to the financial services company. So the clause in Marshall wasn't in any way designed to protect the company's right to receive payment for work done, which is the purpose of the commission provision in the present case. Can we turn then to what we say are the judge's errors on this particular issue? His fundamental error, we submit, was deciding on a summary basis that the commission provision would operate in restraint of trade. And he dealt with this issue in those 3 paragraphs that I've highlighted earlier, paras 99 to 101. The decision and reasoning in those paragraphs is brief and doesn't properly engage in our submission with the issue as to whether this provision would in practice operate as a restraint. It doesn't address why Mr. Javor would put at risk his long-term relationships with artists on Mr. Strange's roster that he had inherited by refusing to complete work on concert bookings on which he'd worked at X-Ray. Rather, in our submission, it appears that what the judge did was to look at the language of the commission provision in isolation from those facts and simply decide that it operated as a restraint, and with respect, that is not the correct exercise. It's necessary to look at how it would operate in practice. At paragraph 99, the judge says that there's no real prospect of X-Ray persuading a judge that it doesn't operate as a restraint at trial. That appears to consider that X-Ray bears the burden of proving that the commission does not operate as a restraint, which is an error. Of course, the burden is on Mr. Javor to persuade a judge that it does operate in restraint of trade. Then the judge goes on to say, I accept the submissions of Mr. Reid and Mr. Solomon that the provision by its terms operates as a strong disincentive to Mr. Javor to work for any employer that has any clients in common with X-Ray. That is an error, because the only evidence before the court was that the representation of artists was, in almost all instances, exclusive. That was Mr. Huffam at paragraph 14. So other employers did not have clients in common with X-Ray, or at least not to any significant extent.
Sorry, Mr. Goulding, I'm a bit behind you. You just showed us the decision of Mr. Sumption, as he then was, at first instance in Marshall and NM Financial. The judge cites the same case in the Court of Appeal. I don't think we've got a case in the Court of Appeal.
No.
Even the future Lord Sumption was only sitting at first instance, and what Lord Justice Millett, as he then was, said, was quoted by the judge, and why have we not got the appeal?
Well, I think the only explanation is it was an authority on which Moylan and Friends relied, and they asked us to put the Sumption decision, if I can call it that. When the matter went to the Court of Appeal, there was no appeal against the finding made by Mr. Sumption that the provision in that case operated as a restraint of trade. So that wasn't an issue for the Court of Appeal, albeit that Lord Justice Millett made that obiter remark, which is cited by the judge below. The only issue in the Court of Appeal in Marshall was whether, if the restraint of trade was excised from the agreement, the payment was still due and owing. So it was a severance point, and the question was whether there was still consideration for the payment, and the Court of Appeal upheld Mr. Sumption on that, to the effect that the commission was still payable. But the issue of is it a restraint wasn't a live issue in the Court of Appeal.
Right, sorry,
Not at all, my lord. And I was just looking at paragraph 99 of the judgment below, it's page 103 in the call bundle, and identifying errors made by the judge. And we say the first is apparent from the second sentence, that he appears to proceed on the basis that X-Ray bore the burden of proving that this would not operate as a restraint. We say that is wrong, because the burden was on the defendants to prove that this did operate or would operate in practice as a restraint. Secondly, in the third sentence of 99, he says that the provision would operate as a strong disincentive to Mr. Javor to work for any employer that has any clients in common with X-Ray. That, we submit, is an error, because the relationship with artists was exclusive, at least in almost all instances, as Mr. Huffam explains in paragraph 14. So for the judge to say operates a strong disincentive to work for employer, has clients in common, is based on a false understanding of the evidence. There were not clients in common.
Well, if the client moved from X-ray to WME, would you use the expression in common?
No, my lord, with respect, one wouldn't. I think that's taken to mean artists who at the same time use different booking agencies. Then at paragraph 100, the judge says Mr. Javor would have to account for commission received by him or a person associated with him, including his current employer, even if his discussions with the client before termination were tentative, vague and inconclusive and did not lead to a booking. Now that, in our submission, fails to understand the way in which Mr. Javor represented the artists he worked with and inherited from Mr. Strange. Just assume for a moment that when working for X-Ray, Mr. Javor had tentative discussions with Coldplay about a concert, but they were inconclusive and didn't then lead to a booking. If when he moved to William Morris, Coldplay followed him and asked him to follow up those discussions that they had tentatively had with him at X-Ray, then it's highly unlikely that Mr. Javor would turn them away and say, no, I'm not going to follow up those discussions, Coldplay, that I had with you, because if I do, I'll have to pay commission to X-Ray. Coldplay and the other artists were too valuable to Mr. Javor for him to turn away in those terms and force them back into the arms of X-Ray. He wanted to hold on to those artists and nurture those relationships. And then the judge says, and even if he were not involved in and not even aware of the subsequent booking of the same artist by the relevant person, that we submit is wholly unrealistic. To think that if Mr. Javor joined William Morris, one of his artists from X-Ray would ask William Morris to contract on a booking on which Mr. Javor had worked at X-Ray without Mr. Javor being involved or knowing anything about it is completely unrealistic and disregards the factual background of the nature of the relationship between Mr. Javor and his artists. Given, as we know from the evidence, that the relationship was exclusive, that Mr. Javor had trumpeted his relationship with these artists when he moved to William Morris, the idea that they would instruct William Morris to work on a booking on which he had worked at X-Ray without him knowing or being involved is, with respect, fanciful. And then the judge says at 100, the last sentence, the obligation to ensure that all such bookings are contracted via X-Ray is absolute and unworkable. That concerns the fourth sentence of clause 13, which in our submission doesn't affect the obligation to pay commission, which is the subject of the third sentence of clause 13. It's the payment of commission that X-Ray seeks to recover in these proceedings pursuant to that third sentence. In any case, the obligation in the fourth sentence doesn't add materially to the obligation in the third sentence. It's simply a way of seeking to police the obligation to pay by saying that if you're working on those concerts, ensure the contract is made with X-Ray. So that doesn't affect in our submission whether or not the third sentence would operate in practice as a restraint of trade. So our submission under ground 2 is that those individual errors compound the judge's overriding error, which is that he wrongly held there was no real prospect that the commission provision will be held not to operate as a restraint of trade. That, we say, is a factual question. It requires investigation at trial. It requires findings of fact. and it can't be properly determined on a summary basis. Lords, can I then turn to ground 3, which I will deal with very briefly. It is that if, contrary to ground 2, the court concludes there is no real prospect at trial that the commission provision would be found not to be a restraint of trade, nonetheless, there is a real prospect that it would be found not to be subject to the doctrine of restraint of trade. As we've seen from Quantum, there is no single test to be applied to decide whether a restraint of trade is subject to the doctrine of restraint of trade. As Lady Justice Carr stated in paragraph 79, public policy remains the foundation of the doctrine. And here the commission provision is, as we submit, unlike any other contractual provision that has been held to be subject to the doctrine of restraint of trade. X-Ray's case and evidence before the judge below, which for these purposes should be accepted as correct, is that the language of the commission provision is of the kind commonly incorporated in employment contracts in the music industry and would generally be viewed as industry standard. That is pleaded in the particulars of claim. If I could just invite the court's attention to that, it's behind tab 9 of the core bundle, paragraph 27.2 on page 122, where it's pleaded the language of the commission obligation is of the kind commonly incorporated in employment contracts in the music industry. And it goes on to say, has a legitimate commercial purpose, where it seeks to ensure the claimant fairly and properly retains the products of the first defendant's work during his employment for the claimant. And in Mr. Huffam's evidence, he deals with this. That's behind tab 5 of the bundle. Sorry, tab 5 of the supplementary bundle, page 33. Paragraph 22, at the bottom, he says, having discussed the commission provision, I believe this would generally be viewed as industry standard. And then he says, over the page at 35, paragraph 28, this type of clause, though perhaps not uniform, is fairly standard in employment contracts between booking agencies and their employees. And we say, in those unique circumstances, it's wrong to decide on a summary basis that the commission provision is subject to the doctrine of restraint of trade. Rather, that's a matter to be considered having regard to findings of fact and public policy after a trial.
Was there any evidence from either defendant contradicting what Mr. Huffam said?
Yes, Miss Dickens for WME said that she didn't accept that it was industry standard. She exhibited to her witness statement the contract between WME and Mr. Javor, which doesn't contain a commission provision of the type in issue here. It did, however, contain a 12-month non-dealing provision. So there was, my lord, a dispute as to whether this was industry standard, but that, of course, is a dispute that can't be resolved on a summary basis. And we submit, as the judge indeed said, that he must accept X-Ray's case on the law and the facts at its highest, and should assume that that is correct for present purposes. And we say in this respect, the commission provision is analogous to the principle that an agent can't profit from a business opportunity of which he learned by reason of his agency, but has to account to a company or to a principal for it. That restriction, which is on one view, a restriction on the agent's ability to trade following the termination of the agency has never been considered subject to the doctrine of restraint of trade. And we say the same would apply here. If this provision, which is concerned to ensure X-ray is properly remunerated for work carried out by Mr. Javor as its employee, is held to be a restraint in practice, it should, in our submission, not be subject to the doctrine of restraint of trade. And that is a matter that can only properly be considered on full examination of the facts and public policy at trial. Lord, that's all I propose to say on ground 3. Ground 4 concerns legitimate business interests. We submit that the judge erred in failing to consider or identify X-ray's business interests sought to be protected by the commission provision. As we have seen, he dealt with the reasonableness of the commission provision at paragraphs 102 to 103 of the judgment, page 103 of the core bundle. Nowhere in those paragraphs does the judge address X-ray's business interests sought to be protected by the commission provision. And in our submission, it's impossible to decide whether a provision is wider than reasonably necessary to protect legitimate business interests without identifying what those business interests are. And his failure to address those business interests vitiates his conclusion on reasonableness. The law on restraint of trade is well known, and I won't spend time taking my lords to any of the authorities that outline the test. We deal with TFS and Morgan in our skeleton argument, and that identifies 3 stages that one has to examine. Firstly, what does the provision mean? Secondly, what are the interests sought to be protected? And thirdly, is it no wider than reasonably necessary to protect those interests? So an essential element of the reasonableness question is, what are the business interests? As to what are legitimate business interests for the purpose of restraints of trade in an employment setting, the categories of legitimate interests are not closed, as Lord Justice Evans made clear in the Dawn Day case. If I could just take my lords to that, it's in tab 4 of the authorities bundle. This case concerned covenants in a shareholders' agreement, and the issue was whether investors in a joint venture company had a legitimate interest to protect in terms of the activities of the individual managers in that joint venture company. If one goes to page 1104, page 70 of the bundle at F, Lord Justice Evans formulates the question, does a joint venturer who's not a partner have a sufficient interest to be permitted to enforce anti-competition and anti-solicitation covenants against his fellow joint venturer when the business is to be developed and carried on by a jointly owned company? And having reviewed the authorities, he stated the correct approach at 1106H, page 72 of the bundle. He said, in my judgment, far from confining the circumstances in which covenants in restraint of trade may be enforced to certain categories of case and defining those categories strictly, the courts have moved in the opposite direction. The established categories are not rigid and they are not exclusive. Rather, the covenant may be enforced when the covenantee has a legitimate interest of whatever kind to protect, and when the covenant is no wider than is necessary to protect that interest. And he gave the answer on the facts at 1108B to C. So the question is whether X-ray here had a legitimate interest of whatever kind to protect by the commission provision. And we say that the interests of X-ray were clearly articulated. They're set out in para 27.2 of the particulars of claim, to which I referred a moment ago. They are to ensure that X-ray was fairly and properly compensated and retained the products of Mr. Javor's work during his employment. And we say that that is a legitimate business interest. There is a curious feature relating to the defendant's responses to ground 4. The first defendant argues that the judge did approach this matter on the basis that X-ray's interests were, as I have outlined them to be, and as the judge summarised them in para 85 of the judgment. Mr. Reed points to 85 and he says, well, in the summary of X-ray submissions, it's recorded that X-ray has a clear and obvious commercial purpose to ensure that X-ray fairly and properly retains the product of Mr. Javor's work done during his employment. In contrast, the second defendant argues that the judge did not make any finding as to X-ray's business interests ought to be protected. And had he done so, he would have found that the interest contended for is not a legitimate business interest. That's Mr. Solomon's skeleton, para 68 to 69. The fact that the defendants interpret the judgment in diametrically opposite ways, we say, highlights the problem of this part of the judgment where the judge did not, in terms, in his reasoning and conclusions, identify what the legitimate business interests were.
Paragraph 85, you're setting out your predecessor's submissions.
Yes. So we say that it isn't right to say, as Mr. Reed says, that the judge effectively proceeded on that basis. Otherwise, if that is the argument, then many of the submissions that the judge summarised that were made by my learned friend Mr. Reed, he would be stuck with those, and a number of those were clearly erroneous. For example, in 76 of the judgment, the judge recorded Mr. Reed as submitting that in Stenhouse there was no direct covenant forbidding Mr. Phillips from accepting insurance business. That's clearly wrong. So one can't say just because the judge said something in the summary of submissions, he proceeded on that basis. What is incontestable is that in paragraphs 102 to 103 of the judgment, where the judge dealt with the reasonableness of the covenant, he said nothing about legitimate business interests.
You say it's a legitimate interest which equity recognises in requiring a fiduciary to account for profits he's made from a maturing business opportunity of a principal.
Well, my lord, he is not. I'm just trying to find where he says that. I know that he does.
No,
It's in 101.
You're saying, you say that.
Yes.
This is the legitimate interest you say arises. It is in fact one that's recognised at law by the rule of equity. It says that a fiduciary who exploits the corporate opportunity, even a maturing opportunity of a company or other principal, has to account for the profits.
Yes. Lord, I was using that as an analogy under my ground 3 to say that in that situation, which your lordship with respect fairly summarises, that restriction on an agent's activity is not treated as subject to the doctrine of restraint of trade. And therefore, by analogy, we say that if this type of provision in the contract in fact operates as a restraint of trade, nevertheless it should not be subject to the doctrine of restraint of trade.
I understand you say that, but it seems all I was suggesting to you, perhaps you don't think it's helpful, is that when looking at legitimate interest, it is recognised as a legitimate interest that a company should be able to enforce as against a fiduciary an obligation to account for profits made from a maturing business opportunity.
Yes, my lord, I fear I was being far too slow in responding to your lordship's intervention. And yes, we say it is a legitimate interest for X-Ray here as the employer to ensure that its employee does not walk off with the business opportunity which he came by as its employee. Now,
That's not quite right, you see. It does permit him to walk off with it. It just says he must.
indeed, well, again, I'm abbreviating, but it says he can walk off with it. There is no non-deal covenant, provided he accounts to X-Ray for the commission on the work that originated with X-Ray. Now, here there's a contract, so the relationship is governed by contract, but we say, particularly in the light of Dawnley Day, that legitimate business interest can be an interest of whatever kind, that it's legitimate for the employer to protect. We say there is such an interest here. The judge failed to address the point. So, my lord, that's on ground 4, error for failure to address legitimate business interests, and that vitiates the judge's entire conclusion, we say, on reasonableness, because you can't assess whether something is reasonable to protect a legitimate business interest without identifying what those interests are. Can I turn then to ground 5, which is severance? Our submission here is that the judge wrongly decided that the commission provision, as he put it, cannot be saved by severance. He dealt with severance in paragraph 103 in one sentence, where he said the commission provision cannot be saved by reading it down, nor by severance. That was the totality of the judge's reasoning on severance, and we submit he was wrong to so find. And therefore, if, contrary to our submissions, the commission provision is a restraint of trade, and assuming for present purposes that it is unreasonable, there is a real prospect that at trial a court would sever any unreasonable parts, leaving an enforceable provision. Grounds 5 is on severance, ground 6 is reasonableness. They could be taken in reverse order, but I'm choosing to deal with them in this way so that when one comes to consider reasonableness, one's considering reasonable subject to any severance that would be appropriate.
Do you accept that if or contemplated can't be severed, you're in trouble?
My lord, I recognise, as I have done in the skeleton, that contemplated pushes the boundaries of what is reasonable. We submit that contemplated would mean contemplated by Mr. Javor, and that it needs to go beyond him simply having a thought one day that a particular concert would be a good idea. Contemplation, to make sense, must mean more than that. So I don't concede that if contemplated can't be severed, then the covenant falls away. But I recognise that it is difficult, more difficult than discussed, scheduled or made to justify. But our submission is it can be severed.
Yeah.
Quite clearly can be severed. And we've set out the test for severance in paragraph 35 of our skeleton. It was clarified in the Egon Zender case. It's no longer necessary, as it was once thought, that severance can only take place where the part to be severed is a separate covenant or is trivial. There are 3 criteria. The first is relatively easy to apply. It's the blue pencil test. The second criterion can generally be ignored in situations such as this, as Lord Wilson explained. And the third criterion sometimes gives rise to more debate as to whether it is satisfied. But when one considers here the language in the provision, again, one reminds oneself what is the core obligation to which Mr. Javor agreed. It is to pay commission to X-Ray. derived from concert bookings on which he worked at X-Ray, but which then materialised after he left. That is the core obligation. And in that context, the word contemplated could certainly be severed. It would satisfy the severance test. It can be removed without the necessity of adding to or modifying the wording of what remained, and it would not generate any major change in the overall effect of the restraints in the contract. And there is a real prospect that that provision, as so severed, would then be enforceable. If the court agrees that that is there's a real prospect of that severance taking place, we would invite the court not to sever now, but to allow the matter to go to trial, and then any issues of severance could be properly decided at trial. Of course, in the alternative, if this court is of the view that contemplated can't be justified and would have to be severed for this appeal to succeed, then of course we would invite the court to take that course rather than dismiss the appeal. We've referred in our skeleton to the word discussed as another potential candidate. Again, we don't concede in any way that that renders the covenant unreasonable. We say that discussed would mean in this context discussed by Mr. Javor with third parties, such as the artists or promoters, and that certainly isn't unreasonable. But again, that is a matter of severance which should be considered in the context of full investigation of the facts and factual findings at trial. So in short, on ground 5, we do submit that the judge made a serious error in baldly finding that the provision can't be saved by severance without considering the test, the candidates for severance, or giving any reasons for that view. And finally, can I then turn to ground 6 on reasonableness? In our submission, the judge wrongly decided in paragraph 102, in his words, that it is obvious the restraint is unreasonably wide and that a trial is not needed to reach that conclusion. We deal with this in paragraph 60 to 72 of our skeleton. Now, turning back to those two short paragraphs, 102, 103, where the judge dealt with this point, the first reason he gives is that the commission, this is paragraph 102, second sentence, the commission provision is not time limited, and the lead times between discussions and concerts and presumably payment can be long, as Mr. Huffam's evidence shows. We say that reason is erroneous for reasons which we spell out in paragraph 64 of our skeleton. First, the absence of a time limit is not of any material significance in view of the fact that the limit on this requirement is that Mr. Javor should have worked on the concert booking when he was an employee of X-Ray. A time limit is more apposite in a case such as a covenant not to solicit clients or deal with clients for a period of time, where one does have generally time limits prospectively and retrospectively. But that is not of significance here, where the limit is inherent in the provision itself. He must have worked on concert bookings as an employee of X-Ray when the commission then materialises when he's working elsewhere. Second, even if the lead times are long, as the judge says, that doesn't render the provision unreasonable when, as I say, the important limiting factor is that Mr. Javor must have worked on the concert bookings at X-Ray. It's unclear even what the judge means by long in paragraph 102. We saw from the schedule of bookings that the vast majority of bookings in that schedule produced in July 23 were to take place in 2023 itself. So not an excessively long lead time between producing that schedule of booked concerts and the concerts taking place. The second reason given by the judge in paragraph 102, the alleged unreasonableness of the covenant, is, as he says, if valid, the commission provision would make Mr. Javor's job with WME not worth his while We address this in paragraph 65 of our skeleton. This is simply, with respect, a bold conclusion by the judge without reference to any evidence, because there was none on the point. There was no evidence from Mr. Javor that this would make his job not worthwhile. And whether it would make his job not worthwhile is a matter that has to be investigated factually at trial. It's not a self-evident proposition by any means. It's notable in this context, we say, that Mr. Javor has taken up the job with William Morris, so it hasn't made his job not worthwhile. William Morris say in response, well, they took advice and they formed the view that the commission provision is not enforceable. So that's the answer to that point. But as to that, we say we don't accept that at face value. That's a matter that has to be investigated at trial. And in fact, if that is to be relied upon, then privilege has been waived in that legal advice. And we would seek disclosure of it should the matter proceed to trial. The third reason then given by the judge for the alleged unreasonableness of the covenant on a summary basis is in paragraph 103, where he says X-Ray could have protected itself within the bounds of reasonableness by means of a non-dealing covenant. We address this in para 66. In our submission, a non-dealing covenant would have been more unreasonable than the commission provision. A covenant that restricted Mr. Javor from dealing at all with artists, say for 12 months, as with the non-solicit with whom he had dealt at X-Ray, would risk bringing that relationship to an end and pushing those artists back into the arms of X-Ray. That would be more unreasonable than a provision that says you can continue dealing with those artists, provided in respect of work that you began at X-Ray, you account to us for the commission. One has to remember that Mr. Javor could start work with any of those artists in relation to any new bookings from day one, and of course keep the commission for himself or for William Morris. It only applies in respect of those where he had worked at X-Ray. Fourth, the judge says in 103, the provision is clearly unenforceable, as was the clause at issue in Stenhouse. And we address this in 67 to 69 of our skeleton. It appears that the judge laboured under certain misapprehensions shared by the defendants as to Stenhouse. I've pointed out that, as recorded in paragraph 76 of the judgment, Mr. Reed submitted there was no direct covenant forbidding Mr. Phillips from accepting business in Stenhouse, which is incorrect. And as recorded in paragraph 81 of the judgment, Mr. Solomon submitted that the judge at first instance in Stenhouse decided the issue on a summary basis, which is incorrect. There was a trial. But on any view, the judge has failed to note the key differences between Stenhouse and the present case, which we have identified. And fifthly, the judge has failed in this section of his judgment to take into account X-Ray's case that the commission provision is generally viewed as industry standard and uses language of the kind commonly incorporated in employment contracts. Standard forms of contract is identified by Lady Justice Carr in Quantum as a relevant factor going to reasonableness. That is paragraph 65, subpara 7 at C. Could I just ask the court to turn that up? It's tab 21 of the authorities bundle. Page 459 of the bundle. Paragraph 65(7) on this page, just above D. Her Ladyship says, factors to be considered when assessing reasonableness between the parties include the character of the business and also, at C, standard forms of contract. So if this provision is, as Mr. Huffam says, generally viewed as industry standard, then that is a relevant factor that goes to reasonableness, which the judge failed to take into account. Before I leave this ground and this part of the judgment, can I just make these observations on paragraphs 92 to 98? They are paragraphs in the run-up to the judge's findings, where the judge speculates on different scenarios, his word in paragraph 97, that could arise, and it illustrates in our submission the perils of speculating without proper findings of fact. In 93 to 96, the judge speculates about what contractual terms could be agreed to ensure that payment is made to X-ray. But with respect, that misses the point of the commission provision. The commission provision is not concerned, or not principally concerned, with the situation where a booking has been contracted. In that situation, commission would generally be paid to X-ray because the contract would provide for that to happen. Rather, the commission provision is principally addressed to the situation where Mr. Javor has spent time and X-ray's money working on a booking prior to a contract being made. And therefore, the judge's speculation in those paragraphs about the terms that X-ray could include in contracts for bookings to ensure it gets paid the commission misses the point. So those individual errors that we have sought to identify, individually and cumulatively, undermine and vitiate the judge's conclusion that this provision was obviously unreasonable without the need to investigate the factual matters at trial.
Can I ask you a question about your submissions in respect to paragraph 102, when the judge refers to the fact that provision is not time limited? As I understand it, your submission is that it's reasonable because it's targeted at protecting the product, and you've added the expenditure that X-ray might have incurred, the product of Mr. Javor's work, whilst an employee.
Yes.
The effect of the clause, is this right, is it recovers 100% of the commission, regardless of the percentage, however one might calculate it, of the work that's been required to procure the event that takes place before he leaves and after he leaves. So do you think the judge has that in mind when he says in paragraph 102 that it's not time limited?
With respect, I don't think that's what the judge has in mind, my lord. He doesn't say that in 102, and if it's something specifically that he had in mind, then one would expect him to say that. What I understand him to be referring to is an argument that often arises in restrictive covenant cases, where it's said, well,
it's too long. I know, I understand that.
not only too long in the future, but too long if you look backwards. Yeah. There has to be a cut-off point, such as there is in the non-solicit here. And I don't think the judge is referring to that with respect. But in any event, my lord, the purpose of 100% commission having to be accounted is based on the booking having originated when Mr. Javor was working at X-ray, as well as any work that he carried out on that project. There will inevitably be a degree of arbitrariness about what percentage has to be accounted. And it's difficult to immediately think of how that could be arrived at if it was not 100%.
Well, in another field, 100% might be called a penalty.
Well, it's certainly not a penalty here with respect, because it doesn't arise on any breach of contract. But that sort of question as to whether the 100% is itself unreasonable is a matter that we respectfully submit has to be examined in the context of a full consideration of the facts, which was not possible on a summary determination. And it would not be right to say on a summary basis, with very limited evidence, and as I recall, no evidence really addressed to this point as to 100% having been put before the court. There is every reason why that should go to trial so the matter can be fully investigated, facts found, and an assessment made as to whether any individual element renders the whole provision unreasonable.
Can I ask in relation to one thing you mentioned earlier, which is that the clients are exclusive? That presumably means that they've entered into exclusivity contracts, is that right?
Lord, my understanding is there were no contracts with clients as such. There's certainly no written contracts
So how
with
is
clients.
So how is the exclusivity defined then?
Because as a matter of fact, the artists exclusively use one particular booking agency. Lords, that just leaves our supplementary skeleton argument and recent correspondence. Can I just deal with that very briefly? Because we do wish to make that application and invite the court to deal with it as part of its judgment on this appeal. The single matter dealt with in the supplementary skeleton argument is the recent payment of commission by William Morris to X-Ray. I hope that my lords have a short bundle, application bundle, as it's called. And the supplementary skeleton argument is at tab 3 of that bundle. And as it states in paragraph 2, payment of what William Morris referred in correspondence to as relevant commission has recently been made in 2 tranches. On the 30th of January, William Morris paid X-Ray a sum by way of commission that William Morris had received by various artists. And on the 5th of February, pursuant to William Morris's authority, Coldplay paid X-Ray commission payable by Coldplay. And as William Morris expressed it, this was commission payable on concert bookings where the concerts were held up until the end of the tax year, 2023 to 2024. In a letter of the 15th of November 24, which appears behind tab 4 of the bundle at page 15, William Morris's solicitors said, firstly, that they maintain that X-Ray has no entitlement to commission in relation to these concerts pursuant to the commission provision. But in the 3rd paragraph, in the interests of preserving Mr. Javor and our client's relationship with key artists, and importantly in the interests of acting fairly and honourably in respect of the strange estate, our client is willing to release commission up until the end of the 23-24 tax year. We submit that those payments are relevant to the appeal for a number of reasons. First, they support X-Ray's construction of the commission provision, in that the commission that's now been paid to X-Ray relates to concert bookings on which Mr. Javor worked. My lords will remember the submission I made early on today, that the proper construction of the commission provision is that it relates to concert bookings discussed, scheduled, made or contemplated by Mr. Javor, and the payment is made on that basis that these relate to concert bookings on which Mr. Javor had worked. Second, it supports X-Ray's case that the commission provision doesn't operate as a restraint of trade. And this is because it's apparent from these payments that Mr. Javor is willing to work for artists for whom he'd worked on concert bookings at X-Ray. William Morris is willing for him to do so, and William Morris is willing to pay that commission to X-Ray because it's concerned to preserve relationships with those artists. That supports our argument that this provision would not, in fact, operate as a restraint of trade. And as we've also said in the skeleton argument, in the William Morris skeleton before this court, it was said that William Morris had made clear that the defendants would not comply with X-Ray's demands to pay commission. It's appropriate that the court should see that, in fact, William Morris has made payments of commission, albeit without admitting any liability. We don't accept that the skeleton or the attached correspondence amounts to fresh evidence, but since that was asserted by the defendants in opposing this application, we have made a formal application to have it admitted. And insofar as the Ladden-Marshall criteria would apply to this material, we say that it is satisfied. The material, firstly, could not have been placed before the judge below, of course, because the payments hadn't taken place at that stage, have only been made recently. Secondly, the evidence is relevant to the appeal and supportive of our case for the reasons that I've outlined. And thirdly, the accuracy of the skeleton and the correspondence is not, of course, disputed. So we invite the court to admit this, to read it, and to take it into account in reaching its conclusion. Would my lords give me a moment, please?
Yes.
Lords, unless I can assist further, those
Okay,
are our
thank you very
submissions.
much, Mr. Goulding. Miss Rooney? Mr. Reed, would you like to make a start?
I'm going to make a start, but
Yes.
it's going to be a short one for these reasons that we've divided up the work between I and Mr. Solomon. However, we felt it's probably best just to deal with the last bit of Mr. Goulding's submissions about his application first, which Mr. Solomon's going to deal with very briefly. It was not my client that made the payments, so his client obviously is a payee, and he will briefly deal with that application.
Yes.
And then I will deal, just to give you an outline, I'm going to deal with grounds 1 to 3, and Mr. Solomon is going to deal with grounds 4, 5 and 6 of the appeal, although within his submissions he's specifically going to deal with the issues about the declarations sought against his client. And in 1, 2 and 3 there's a degree of overlap, but we hope to make sure that you're not bored by repetition.
Yes, Mr. Solomon.
I won't repeat what Mr. Reed has said, but I can't promise not to bore the court, of course. Just dealing very briefly, if I may, with the application. Your lordships have the application bundle, and at the end of it, at page 28, those instructing me wrote a letter setting out their opposition to the application. Can I make very clear at the beginning? I'm going to spend just a couple of minutes on this point. We want to deal with the substance of the appeal and not with this satellite matter, and time is tight, and that's why I'm going to be brief.
Yeah.
But, Mr. Goulding outlined how much time each party was allowed, and we would say that any time spent on this application must come out of the appellant's time. The letter at page 28 to 30, page 28 to 30, makes a number of points. One of the points it takes is that the application was made very late, just over a week ago, and as Mr. Goulding has told you, it relies on correspondence from the 15th of November of last year about the fact that my clients intended to make a payment. I'm not going to take a point on timing of the application, notwithstanding that is relevant and significant, but your lordships have been shown the letter of the 15th of November at page 15. Can I ask you to turn to that again? What Mr. Goulding did not ask your lordships to read was the second paragraph, the first and second paragraphs of that letter at page 15. First paragraph makes the point that the legal position is that your client has no entitlement to commission in relation to concerts contracted. And that was our position in the skeleton argument we advanced, and it remains our position. There is no factual error that needs to be corrected in our skeleton argument, notwithstanding my original skeleton was put in before this payment was made, and the replacement skeleton is exactly the same, save with page references. And the second paragraph makes the point that our client, Mr. Javor, were disappointed to hear that your client's delayed making payments to Steve Strange's estate. So your lordship will have seen that there were discussions between the first defendant and the appellant, first respondent and the appellant, about payments to be made to the Strange estate. And these payments were made to the appellant on the basis that they would be made thereafter over to the Strange estate, but they haven't been, as I understand it. And so what my clients did is make payments because of a moral, not a legal obligation, notwithstanding their open and remains open position is that there was no obligation to make those payments. Now, my learned friend Mr. Goulding addressed your lordship on the relevance of these payments recently made to the grounds of appeal. He made 3 points. He says it goes to construction, it goes to restraint of trade, and it goes to the fact that we can comply with the obligation, therefore there's no restraint on Mr. Javor. On the first point, on construction, 2 short points, if I may. The grounds on which the judge below construed the contract and the basis on which he construed the contract are not grounds of appeal in this court. So there is no ground of appeal which said the court below misconstrued the contract. And my learned friend now is asking you to take into account payments made very recently in determining the construction of the contract. That's simply not a matter before this court. But in any event, and much more fundamentally, not addressed by Mr. Goulding, notwithstanding it's in our letter that I've shown you that we wrote last week, construction of the contract must be made as at the date the contract is entered into, and facts and matters which occur thereafter are inadmissible to questions of construction. So my learned friend has simply asked your lordships to take into account a purely prejudicial and an inadmissible set of facts. The same point pertains to the question of restraint of trade. So, my lords, in my skeleton argument on appeal, paragraph 40 at page tab 3, page 53 of the core bundle, we set out all the cases that say over and over again that the reasonableness of a clause is to be judged as at the date of the contract. And so the fact that a payment has been made recently is entirely irrelevant and, again, inadmissible to the reasonableness of the clause. So my learned friend simply cannot take this into account and ask your lordships to do so when determining whether or not it's in restraint of trade. And the third point is that my clients are able to comply with the payment obligation. That is a purely prejudicial submission which has no impact on the questions of law which your lordships are asked to determine today. And so for all those reasons, my learned friend has read the skeleton into the court. It is purely prejudicial. We say actually your lordship should not admit it. It was wrong for the appellant to seek to put this before your court. It's purely prejudicial. It's all inadmissible and it should form no part of your lordship's determination.
Right. Unless it would greatly inconvenience you all, it seems to me that we should consider our ruling on this issue over the lunch break, and if we come back at 5 to 2, we'll tell you what it is, and then Mr. Reed can take up the baton on the main issues.